Hi everybody, this is Xiaosheng Huang practicing immigration law nationwide in the United States. Today I'm talking about a case I recently handled. A Taiwanese guy came to the United States to get united with his mother. His mother filed I-140 many years ago. That's the F2B category because his mother was a permanent resident, never become a U.S. citizen. So the child waited about 8 years get over here, and he actually got a B1 B2 visa to come to this country. He got the visa many years ago before the Taiwanese were granted a visa waiver program. So the I-130 priority date is up. He filed the I-485 with the USCIS. At time of the interview, it seems a very approvable case. The ex-lawyer prepared it nicely, but eventually it was denied. Why? Because on the I-485, he put a yes to a question like, have you ever been arrested? He put over there that yes, I was arrested in Taiwan because of shoplifting, and at like 20 years old, I stole some cell phone from a store. So I was just arrested for shoplifting, fined, and didn't have a jail time. The officer said, okay, thank you for being honest to me, but the problem is you committed the 212A6CI, the fraud of misrepresentation. Why? Because shoplifting is not a big issue. Even though you have shoplifting, you are able to get a green card because shoplifting falls under the category of petty offense exception for the criminal conviction. And that's not a problem. That's not a problem. So you can get your green card. The thing is, you lied to the visa officer in Taipei. So when you apply for the AIT, based on my research in the system, you didn't disclose you were arrested in Taiwan for shoplifting. You, in case you disclose, the visa officer many years ago may deny your visa. So the USCIS officer here in the US denied the I-45, and years ago put him into the removal proceeding. That means he has to talk to the judge in the immigration court. If he did not convince the judge, he would be deported. That's called a removal proceeding. Then he hired me. I went to the court, refiled the I-45 and I-601, which is a waiver for inadmissibility, not because of the shoplifting, but because of the fraud and misrepresentation. And I caught of the here at a court hearing, I convinced the judge this guy deserves a waiver because I went to visit his mother's farm in a mountainous area where his mother worked very hard with his stepfather on the vegetables, farming products, and fruits. So I take a lot of pictures and bring the mother, stepfather, and even the neighbors to the court, and telling the judge that he is very essential to the family. The mother is getting old, getting ill. His mother is not, stepfather are not able to take care of the farming business. And if the son is not able to stay in the United States with them, they have to sell the farm, and they will have to terminate supply to the local vegetable, fruit, or other farming products market. So he is considered as an essential worker, and his mother will suffer extreme hardship. His mother has only one child, living with him together in the U.S. Some siblings living in Taiwan cannot come here, and with all the medical documents, all the supply chain documents and photos, and how this guy worked so hard in the farm, and how difficult the mother and the stepfather would face if in absence of this guy, this whole family will collapse. So the judge eventually granted the I-601 waiver, and he got the green card eventually from the USCIS. So basically, the immigration law is about telling a good story. Is you have to really tell the judge or the DHS counsel a very moving story how common people make a living, to survive, to help around, and to contribute to this country, to the community. So I won the case, and even the DHS counsel doesn't want to appeal. So making my client very happy. So I just want to share this story on this weekend. Thank you.